I want to start this video out on this right here. I found another way to do them except for going around this way each time. And I think it kind of works out a little bit better. And I want to try to show it to you. And I think it worked out pretty good. And they're looking better than I figured they would. But I'm doing like every other one this way. And then I'm going back and I'm doing these. Now, there's one that I got that kind of like really comes out really long. So I kind of got to watch that one and not let that happen. But these seem like, where are they at? Okay, there's one. And I should have one more in there. There it is. And try not to have that one show up really big. But I think that works out a whole lot better. And then I still have been sewing it down the same, like taking it and hiding my knot in there and going on with it. But that's the way I've been changed onto, because it seems like it does better. I kind of like it better that way. So you got all three of them going inward. It does work. But I did have a couple of them really big. Like that one. It's really big in that one. So I have to kind of watch that. I have to manipulate it to go where I want it to. Alright, there we go. These together. Alright, I've already done started on this. I've got this one done and I'm working on this one now. And then I'll move to this one and then I'll move on down to those. Now I've got talking about the amendments and the Constitution and all. And I want you all to hear it. I want you to pay attention to what and all is being said. And I want you to keep in mind jailhouses, and I want you to keep in mind the cops, the police, because I think that some people just really don't understand about what the amendments and the Constitution and all are really about. So I'm going to do some sewing, and I would like for y'all to listen to it. And if you want to leave a comment, you can. But I have a couple more of these that I want you to hear. So I'm going to sew and let you listen.
The Bill of Rights and the 17 other amendments to the Constitution. Track 1. Bill of Rights, General Contents. The Bill of Rights contains the first 10 amendments to the United States Constitution. These amendments serve to limit the power of the federal government. They serve to protect the rights of citizens, residents, and visitors. Among the rights are freedom of press, religion, and speech, the right to keep and bear arms, the freedom of assembly and petition, and the rights to be free of forced self-incrimination, cruel and unusual punishment, and unreasonable search and seizure. The Bill of Rights also explicitly reserves all powers not granted to the federal government to either the people or the states. It prohibits the government from depriving any person of life, liberty, or property without using the due process of law. In criminal cases, it requires an indictment by a grand jury for any capital or major crime. It guarantees a speedy trial with an impartial jury locally. It prohibits double jeopardy or being tried twice for the same crime. Track 2. Contents of the other 17 amendments. Only 17 amendments to the Constitution have been ratified in over 200 years. The first 10 are commonly referred to as the Bill of Rights, ratified only a few years after the Constitution itself was ratified. 9 of the remaining 17 relate to how the federal government operates. 4 provide equal rights to African Americans with specific stipulations to protect those rights. Only 4 relate to other issues, 2 with regard to liquor, 1 denying its use and the other repealing that amendment, the third a federal income tax, and the final one confirming women's right to vote. The 9 that address federal government issues are 11 limited the jurisdiction of the Supreme Court in 1795, 12 provided for a redesign of presidential selection, 17 provided for direct election of senators by the voters, 20 moved up the date presidents and Congress took office, 22 created the 2-term presidential term limit, 23 gave the District of Columbia electoral votes, 25 provided for the presidential disability procedures, 26 allowed citizens to vote at age 18, and 29 provided restraints on congressional pay raises. Of the remaining 8, half relate to slavery issues. 13 prohibits slavery, 14 guarantees the rights of citizens and all other people, 15 specifically confirms black men's right to vote, and 24 prohibits voters being disenfranchised for a failure to pay a poll tax. 2 relate to the prohibition of liquor, 18 prohibiting liquor, 21 repealing 18. 16 authorize the collection of federal income taxes, and 19 specifically confirms women's right to vote. Track 3. General origins of the Bill of Rights. The Bill of Rights emerges from the concerns expressed by the anti-federalists, or those who feared a strong federal government, and those such as Thomas Jefferson and the author of the Bill of Rights, James Madison, that wanted the people's rights explicitly recognized. The Bill of Rights was drafted by James Madison, who also wrote the Constitution itself. Madison was perceived by members of the Philadelphia or Constitutional Convention in 1787 as a fair person concerned with both the interests of the Federalists and the Anti-Federalists. The Constitution was passed at the convention and ratified by the states, largely on the good faith dealings of both parties, the Federalists and the Anti-Federalists, promising to do something about the people's rights. James Madison earned this trust through his statements to Congress and the document itself. He stated 2 important things. When submitting his proposal to Congress on June 8, 1789, for the Bill of Rights, he said, quote, "For while we feel all inducements to go into a revisal of the Constitution, we must feel for the Constitution itself and make that revisal a moderate one. I should be unwilling to see a door opened for a reconsideration of the whole structure of government, for a reconsideration of the principles and the substance of the powers given. Because I doubt if we should be very likely to stop at that point, which would be safe to the government itself. But I do wish to see a door open to consider so far as to incorporate those provisions for the security of rights against which I believe no serious objection has been made by a class of our constituents." Madison went on to state, prior to stating his proposal for the number of amendments, that the bill sought to address some of the discontent with the Constitution as drafted. Quote, "I believe that the great mass of people who opposed the Constitution disliked it because it did not contain effectual provision against encroachments on particular rights, and those safeguards which they have been long accustomed to have been interposed between them and the magistrate who exercised the sovereign power. Nor ought we to consider them safe, while a great number of our fellow citizens think these securities necessary." Unquote. The Bill of Rights was the result of these promises and negotiations. 12 amendments were proposed. The first, dealing with the apportionment of the House of Representatives, was never passed. Another was not ratified until 1992. The traditional usage has continued, referring to the Bill of Rights as having 10, not 11 amendments, even with the passage of the 27th in 1992. The bill, as it has come to be referred to as, was influenced by Magna Carta in 1215, the English Bill of Rights in 1689, the Declaration of Independence in 1776, and the Virginia Declaration of Rights in 1776 as well, and finally the Virginia Statute of Religious Freedom in 1786. It was further influenced by ideas from the Enlightenment and more specifically from John Locke and English common law. Track 4. Argument against the Bill of Rights, led by Alexander Hamilton. Hamilton argued essentially that the Bill of Rights was unnecessary. This is what led Madison late to address this issue directly, as quoted earlier. Quote, "Nor ought we consider them," editor, the rights, "safe, while a great number of our fellow citizens think these securities necessary," unquote. Madison, in effect, said, while Hamilton's criticism might be valid, that the bill was unnecessary, if it gave comfort to, quote, "a great number of our fellow citizens," unquote, it was worthwhile. Hamilton made his most eloquent arguments in the Federalist Paper number 84. He stated that ratifying the Constitution did not mean the American people were losing any rights, and therefore a Bill of Rights would be unnecessary. Quote, "Here, in strictness, the people surrender nothing, and as they retain everything, they have no need of particular reservations," unquote. Hamilton went on to say that the Constitution was inherently different from earlier political agreements between sovereigns and subjects as reflected in Magna Carta and the English Bill of Rights. Quote, "Bill of Rights are in their origin stipulations between kings and their subjects, abridgments of prerogative in favor of privilege, reservations of rights not surrendered to the prince. Such was Magna Carta, obtained by barons, sword in hand, from King John," unquote. Hamilton continued, clearly in favor of the British system of common law, which did not quantify, limit, or define natural or individual rights. They believed that adding a bill would limit their rights to those listed in the Constitution. Clearly a valid point. So Madison included the Ninth Amendment to address this concern directly. Hamilton stated, quote, "I go further and affirm that Bill of Rights, in the sense and in the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted, but on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do?" Unquote. The Federalists thus made their case. The proposed Ninth Amendment let them alter their judgment and accommodate the concerns of the Anti-Federalists who wanted the additional protection referred to earlier by Madison. Track 5. Anti-Federalists. Many of the older delegates to the Philadelphia Convention in 1787 raised concerns about the abridgment or lessening of states' rights and those of individuals. One of the leaders was the great Virginia orator Patrick Henry, who came out strongly against the Constitution. Their primary concern is that this fledgling democracy, the first in 2,000 years since the Athens of Pericles, was likely to drift into the president becoming king, and the people needed additional protections such as a bill would provide. Jefferson concurred at a distance as then minister to France. Patrick Henry spoke before the Virginia Ratification Convention in 1788 in opposition to the Constitution by saying, quote, "Is it necessary for your liberty that you should abandon those great rights by the adoption of this system? Is the relinquishment of the trial by jury and the liberty of the press necessary for your liberty? Will the abandonment of your most sacred rights tend to the security of your liberty? Liberty, the greatest of all earthly blessings. Give us that precious jewel, and you may take everything else." Unquote. Jefferson stated that the Declaration of Independence implied the people would have the protection of a bill. When challenged with the idea that a bill might be unwieldy, Jefferson wrote his colleague Madison, quote, "Half a loaf is better than no bread. If we cannot secure all our rights, let us secure what we can," unquote. And this Madison did. To provide a formal response in a collection of essays referred to as the Anti-Federalist Papers, in a mirror image in number 84, Robert Yates, as was thought then, though writing as, quote, Brutus, unquote, anonymously, said, quote, "Ought not a government vested with such extensive and indefinite authority to have been restricted by a Declaration of Rights," unquote. Track 6, the Massachusetts Compromise that led to ratification. The Anti-Federalists made their stand in the Massachusetts Ratification Convention. John Adams and John Hancock, two leading Anti-Federalists, negotiated a far-reaching compromise that led to the ratification of the Constitution prior to the bill being drafted by Madison. The compromise was that the new Congress would review the request for a bill. The good faith of the Federalists was relied upon, and Massachusetts led the way for themselves and others to ratify the Constitution. Massachusetts became the sixth state to ratify, with 9 needed. 4 of the next 5 states to ratify also included similar language to that of Massachusetts. This led to Congress doing exactly that and proposing the bill be adopted by the states after they first met in 1789. Track 7, Antecedents. John Locke, in his 1689 book, Two Treatises on Government, had the most impact on Madison. Locke proclaimed that civil society was created for the protection of property in the sense of life, liberty, and estate. Locke also proclaimed that each person is free and equal in the state of nature and should be permanently given those rights by their respective governments. Madison references this in the above quotation in his presentation to Congress. The Virginia Statute of Religious Freedom and the Declaration of Independence were drafted by fellow Virginian Thomas Jefferson. George Mason, also from Virginia, drafted the Virginia Declaration of Rights. The other major influence was the English Bill of Rights. This differed in that the intent was to deal with the rights of citizens as represented by Parliament, not directly to themselves, with regard to the monarchy. The basic beliefs are similar, however: an independent judiciary, freedom from taxation without parliamentary approval, the right of petition, the right to bear arms, freedom of speech from cruel and unusual punishment, excessive bail, and fines and expropriation of property without trials, and from a peacetime standing army. Track 8, Incorporation by States. The bill applied to the federal government and not the states. Madison suggested this be modified to incorporation by the states. In other words, the states would be bound by it. This was rejected by Congress. This led the states to do a number of things on their own, including setting up establishment churches, banning abolitionists, among other things. The Supreme Court, through a series of rulings, made the states toe a tighter and tighter line in this regard, though today the ruling is still not absolute and is still termed, quote, selective incorporation, unquote, a somewhat ambiguous term at best. Track 9, Reading of the Bill of Rights. Amendment 1. The first 10 amendments are commonly called the Bill of Rights. Dates and facts. The first 10 amendments, referred to as the Bill of Rights, was proposed on September 25, 1789, and ratified by the necessary majority on December 15, 1791, 811 days later. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when it is in actual service in time of war or public danger. Nor shall any person be subject for the same offense twice, put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Track 10. Reading of the other 17 amendments. Amendment 11. Provided limits to Supreme Court jurisdiction. Dates and facts. Proposed on March 4, 1794, and ratified February 7, 1795, 340 days later. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Amendment 12. Redesign of presidential election process. Dates and facts. Proposed on December 9, 1803, and ratified on June 15, 1804, 189 days later. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in district ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest numbers, not exceeding 3 on the list, of those voted for as president. The House of Representatives shall choose immediately by ballot the president, but in choosing the president, The vote shall be taken by the states, the representation from each state having one vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Amendment 13 specifically prohibits slavery. Dates and facts. Proposed on January 1st, 1865, and ratified on December 6th, 1865, 309 days later. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Amendment 14. Guarantees rights of citizens and other people. Dates and facts. Proposed on June 13, 1866, and ratified on July 9, 1868, 757 days later. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridges, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or a judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debt incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Amendment 15 specifically confirms black men's right to vote. Dates and facts. Proposed on February 26, 1869, and ratified on February 3, 1870, 342 days later. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 16. Authorized federal income tax. Dates and facts. Proposed July 12, 1909, and ratified on February 3, 1913, 1,302 days later. The Congress shall have power to lay and collect taxes on incomes from whatever sources derived without apportionment among the several states and without regard to any census or enumeration. Amendment 17. Direct election of senators by voters, not legislatures. Dates and facts. Proposed May 13, 1912, and ratified on April 8, 1913, 330 days later. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution.
I hope you enjoyed this, and I'm going to put the rest of it up on the next video. And then we have 2 more after this one, and they are more teaching you how they are not using the Constitution, and it has nothing to do with what God wants us to do. Thank you. All right.